any needs that you may have. But rumor has it that 4th of July weekend, all of our agents were out there working hard, passing out flyers, door knocking, open houses, burning calories. That's what I heard. So as your lender, I thought I'd replace those calories with peanut butter cookies. So after the class, please join us, help yourself with some peanut butter cookies, and if you have any mortgage questions, I'm here to help you. Welcome to the class.
Thank you.
Of course.
And you guys, don't forget when you're over here grabbing the delicious
Peanut
cookies
butter with
that,
calories.
that Sylvia brought. They're delicious.
And calories.
Yes.
Don't forget, there is a barcode. And so if you guys could please scan the barcode and leave us a review for Legacy Trust, that would be amazing. Also, there's new branding for the parent company for Champions, and I have some t-shirts over there. So, pick up a t-shirt, get your size, so you guys can, work out with the Champions branding. There's a class, when is it? Next week sometime, the Models Explained. Is it Tuesday? So Tuesday at 10 a.m., if you guys want to be here as well. I'm going to go through all of the models that Champions now offers. So we have different models that are now available. That is a class to go to if you're kind of curious about the real RE/MAX acquisition, about what Champions Real Estate offers versus RE/MAX versus Real. So mark that down if you guys want to come join for Models Explained and a lunch. I'd love to have you guys. And with that, where is Rod?
Rod.
Where is Rod? Is Rod in the house?
Right here. All right.
Thank you, Rod.
Okay, I love that. It's so exciting, I'm applauding before I do anything. It's definitely an improvement. So you drive from here to, let's say, Santa Monica, and you take, let's say, the 210 freeway, and then you take the 10 freeway, and you go all the way to the beach. There's billboards all along the stretch. And what's the number one billboard that you see in terms of category? What do you see? Lawyers. So there's an uptick in litigation in the state of California. Like, we need to announce that there's an uptick in litigation. There is an uptick in litigation. Unfortunately, it's not just PI guys suing in car accidents. I've seen probably a threefold increase in litigation against residential real estate agents this year, since January 1. A lot of litigation. And you folks probably know where it comes from. What's the number one source for litigation against you folks? Whether you're a listing agent or a selling agent, where do most of the lawsuits come from? What are they about? Disclosures and inspections. Keep that in mind, and we're going to circle back to it in a little while. This is largely going to be a Q&A, by the way. That's what it was advertised as. This lecture is not going to be one where I pontificate for an hour and a half and then have a couple questions at the end. This is designed to be for you folks. So I'm going to introduce a couple of topics, and in between, we'll just fire the questions and I'll fire the answers. And that's kind of what this is intended to be. We've done this for about 7 years. Or mid-year, I come back to speak, and we talk about what you have in mind and your questions. We give you answers. Things that kept you up all weekend, knowing I'd be here today, will be now the time to ask you questions. So I know a lot of you were up Saturday night thinking, I can't sleep because I have these legal questions just stirring around. And I can't wait to see Rod so I can ask him. And you didn't sleep Saturday night, you didn't sleep Sunday night, you probably didn't sleep Monday night, but now here we are and we're going to get the questions answered. But before we go any further, this is an interesting topic that I don't think we've actually spoken about before, but I get a lot of calls on it. It's not like gigantically legally significant, but it creates a lot of indigestion for my buyers, sellers, and listing and selling agents. We're going to talk about appraisal reports and inspection reports. I can't tell you how many battles have been waged because the listing agent or the selling agent are complaining that they're not getting a copy of the appraisal report or they're not getting a copy of the inspection report. So I'm going to end it. I'm going to tell you what you need to do as a seller and a listing agent with respect to those reports. As appraisal reports, who thinks that 100% of the time the seller and listing agent are obligated to give the buyer a copy of the appraisal report? Anybody say 100% of the time it goes to them? How about 50% of the time? How about 0? Okay, no opinions in the room. So that's exactly why I'm speaking about it, because nobody knows the answer, but it's hidden in the RPA. And here's the answer. So if you have a transaction that has a financing and appraisal contingency, and your buyer is canceling because of the appraisal is low, then your buyer has a legal obligation to provide the seller with a copy of the appraisal report on request in connection with their cancellation. So again, if you represent a buyer and the deal was put together with an appraisal contingency, and your buyer cancels because of the appraisal contingency because the property didn't appraise, then along with your cancellation, if on request, you serve a copy of the appraisal report. That's a requirement upon request of the listing agent along with your cancellation. And if you want to look it up and read it yourself, it's paragraph 8B1. And you'll find the language it's hidden. Remember, we now have a 17-page contract that nobody reads, nobody understands. They just sign it, most of the time electronically. They don't even see the print. All they do is they see it electronically, they see their signature and they hit it, and they don't even know the contract they're initially signing. So now it's even worse than it was before. But appraisal report goes to the listing agent when your client as a buyer cancels based upon the appraisal. In all other circumstances, if your client's canceling because of, let's say, an inspection report, or for any other reason within their 17-day window, you don't have to give a copy of the appraisal report. Only time buyer gives the appraisal report is if their cancellation is based upon a low appraisal. That should end it with respect to questions on when you're obligated to give the appraisal report to the seller. That should end it right there. 8B1's your paragraph. Then you can review it tonight. I usually say turn on the fireplace, you cuddle up by the fireplace, and then pull out the RPA and then read it. But it's a little warm to do that. So probably do it during your dinner. So when you have dinner and everybody's around the table, pull the RPA out, go to paragraph 8B1, and just read it to everybody. And they'll enjoy it. Now let's talk about inspection reports. This is one that I have a lot of battles over. Probably every single week, I've got a listing agent and a selling agent battling it out because they don't get a copy. The listing agent says, I want a copy of the inspection report. And the selling agent says, I'm not giving you a copy of the report you paid for. Well, I want a copy of it. I'm not giving it. And then they call me. So now we've taken a non-issue and we've interjected a lawyer into it, which is really smart. And now we're arguing about something that has nothing to do with the underlying deal. And it happens every week. So how many people think that the seller has no right to a copy of buyer's inspection report?
Well, if they're not asking for any repairs, why should he get it?
Okay, so there's one qualification. If they're not asking repairs, when should they get a copy? Here's the answer. And I'll give you the paragraph first because you're going to want to read this at the dinner table too. It's paragraph 12D. 12D, D is in Delta. And I'll just read it word for word. It'll answer everything for you. By the time specified in paragraph 3L3, which is what, 17 days, or 3 days after receipt of any inspection report, whichever occurs later, give seller at no cost complete copies of all inspection reports. So it's an unqualified duty on the part of the buyer to give the seller copies of every single report, even without a request. Yes?
I have a question on that one. Okay, what if we don't, as a listing agent, we don't want a report?
Well, I mean, that might be, that's an interesting question. So if you ask, you don't have to ask for it. Buyer's obligated to give it to the seller automatically.
Because if we get that report.
Well, I know. We're gonna get to that. There's the problem. There's the problem. So I understand what we're talking about here. Let's read this out first. We're talking about what the buyer's obligated to do. The buyer's obligated to give all inspection reports. What's an inspection report? A home inspection report, a foundation report, a roof report, a termite report. Any report that relates to the condition of the property that the buyer has, the buyer technically has an unqualified duty to give it to the seller. If seller doesn't ask for it, it still goes to the seller. If seller asks for it, it goes automatically to the seller. It doesn't matter. Buyer gives the copy of the reports to the seller. Now, you have a deal, it's coming apart, it's canceled within the 17 days, you know there's an inspection that was done, nobody offered it to you. Now, maybe as a listing agent, you don't want to see it. So let's say you don't get it. You say, no, I didn't get a copy of it. So now you got buyer number 2, and he shambles into the deal, and they write an offer, and they're going down the path. Do you have any duties with respect to the inspection report you didn't get? With buyer number 2, you have a duty to tell them it was inspected, but that you never got a copy of the report. So you'd still need to disclose that it was inspected and that the buyer never provided a copy of the report. If you have the report, it automatically goes to all future buyers, which is what her concern is. And it might be a disgusting report. I mean, not all reports from home inspectors are valid and legitimate. And I give an example of a property I have personally down in Orange County. And I was gonna sell it about a year ago, and I'll tell you firsthand, it's in mint condition in every way. I spent $300,000 remodeling it, and it is perfect. I got a 119-page inspection report that made it look like a shack. Well, clearly it's inaccurate. None of it was accurate. The biggest complaint was that the screws on the light fixtures were not vertical, they were horizontal. Honestly, yeah, I mean, stupid stuff. One was that one of the drawers wouldn't open. Well, it wouldn't open because there was a towel that wouldn't close. There was a towel cut in it. I mean, that's how stupid the inspection report was. So, sometimes when you ask for the report as a listing agent and you say, I want it, you might be doing your seller a disservice. So here's I'm just telling you, as a buyer, always give it to the seller. That's a requirement. As a listing agent, you may not want it. So if the buyer doesn't give it to you and your seller says, I don't want it, then you don't have a duty to ask for it necessarily. But you do have a duty to disclose a report was done. You have that duty. And if you know who the inspector was, you probably also have a duty to tell the new buyer that it was done, and here's the person that did the inspection. So regardless of whether you have it or not, it doesn't mean it doesn't exist. You still have a duty to tell the new buyer that this report was done. You don't have a copy, and here's who did the report. And then they can go find it if they want to pay for it. Okay. Any questions on inspection reports or appraisal reports?
So you're saying regardless if the seller does not, let's say you have the report, the next buyer comes along. Regardless if the seller did some of the repairs and then now does not want to give the old report, then you still have to give the old report.
If you have a report that was done within a 12-month period that precedes your sale, it goes to every buyer. At that point in time, goes to every buyer. So if you have a report, I use 12 months, that's not a golden rule, but I mean, typically speaking, anything over that would arguably be an expired, invalid, maybe irrelevant report, but certainly, absolutely, 100%. If you have a report that's 12 months old or less, automatically listing agent and seller give it to the buyer. Automatically, unqualified, even if the seller did the repairs. Yes?
Yeah, do we need to ask the previous buyer approval to share the report? Because, I noticed like on the inspection report will be stated.
Yeah, I'll answer the question.
For that buyer.
I'll answer the question.
Yeah.
You don't ask the buyer for permission because it's a requirement in the contract. So if you have it, you have a legal duty to give it to the next buyer.
Even though the
Regardless.
inspection report stated this report only for that buyer.
Doesn't matter who it's for. Your statutory duty under California law to disclose prior reports and your contractual duty as a seller, as a seller under a future purchase contract obligate you to give the report to the
So we
buyer.
don't need to ask them.
No, it automatically goes. It's an overarching law. For example, this happens all the time too. I'll get a call from a listing agent, and the listing agent will say, my buyer had an inspection done, and the inspector said that the roof was bad, it needs to be replaced. But then my seller rather said that. And my seller said, as a listing agent, I'm not supposed to tell anybody. So I have a fiduciary duty to my seller, so I guess I have to keep that information confidential, right? I hear that all the time. Is that a valid legal argument or an invalid legal argument? Obviously, it's invalid. It doesn't matter what your client says. You're a professional and you have duties and obligations that exceed what your client wants you to do. You have a duty to disclose. If your client says don't disclose, your duty to disclose prevails over client instruction. Okay?
Kind of piggybacking off of what your concern is, can we as a listing agent say we don't want the reports?
No.
No.
If you say that, then it looks like an act of concealment. So then if I were suing you, and as a buyer I came in, and I said, well, this agent told the previous buyer, I don't want a copy of the report. Obviously, you knew something was bad, and it makes you look terrible, even worse than if you just got the report and concealed it. It's almost even worse. Yes,
Legally, okay, what if 3 years, we had a report 3 or 2 years behind? Are we legally responsible to give that report if it was 2 or 3 years?
well, I mean, typically speaking, it's a year, but if you have it in your file, it's in your possession, the golden rule is give it to the buyer, and let the buyer determine. But I usually take a year, because after a year, depending on the circumstances, it may be totally different. The facts may be different, and so the report's not usually that valid after a year. Yeah, so if you turn it over and say, here's a 2-year-old report, but the place is vastly different now, and so it may not apply. Yes. Yes.
Question, so does it mean that, for instance, I'm representing a buyer and someone already did an inspection report on the property, does that report is going to take place instead of us doing another report, or?
No, it doesn't mean that because you have a report as a selling agent from another buyer, it doesn't mean that you tell your client to rely on it. Your client should always be counseled to get his own inspection report. This is just additional information along with all the other seller disclosures that the seller is obligated to turn over. The seller's obligated to turn over prior inspection reports within 7 days, just like all other documents and disclosure, TDS, SPQ, lead-based paint, inspection reports. All that goes together 7 days from the date of acceptance. Okay, yes?
How about if the first buyer canceled due to the inspection,
Yes.
and then the second buyer asked why did the first buyer cancel? Do I have an obligation to tell them because of the inspection?
No, all you do is give them a copy of the inspection report. You don't need to provide details of
Because you will ask
cancellations.
why the reason is the first buyer.
Yeah, it doesn't matter. That's not something you legally have to tell. I mean, that's just a contractual deal between buyer and seller. But you do have to give all the inspection reports over to buyer number 2. And then the buyer can make the decision whether they want it or not. I mean, I've had some wild cancellations. I had one buyer cancel because they had a dream at night that there were rats in the attic. Well, I mean, you really want to tell a new buyer, well, yeah, it was canceled because this buyer had a dream that there were rats in the attic. Well, I mean, there's some wild examples of why buyers decide to cancel. And buyers become irrational too when they're spending $1 million for a 2-bedroom, 1-bath, 800-square-foot house in Montclair. And they get irrational sometimes. All right, nothing wrong with Montclair. I was raised in Montclair. Go ahead.
Going back to the appraisal.
Yes.
They only can cancel and get a report if it's lower. What if they cancel for any reason and it's an FHA?
It doesn't matter if it's not lower. If they're canceling because of the appraisal report, if that's the reason for their cancellation, then the appraisal report goes to the seller. Okay? If they're canceling for any other reason, you don't have to do that. By the way, just so you know, this is a newsletter that was circulated about 2 weeks ago, and the office has it. So if you want details on inspection reports and appraisal reports, this is written up and the office has it. You request a copy and they give it to you. That's one. I know a lot of you don't have time to read it, so I wanted to bring it here. Has anybody read it? Has anybody ever seen? Okay, I've got a handful. Not bad. All right, so let's move on. We're going to talk about something. Yeah, what do you have? No problem.
So even if they're just inquiring about it, why it canceled, the buyer canceled.
Yes.
You're still obligated to give them a report.
Yes. Whatever's in your possession as a listing agent goes to every buyer.
Okay.
Okay? Yeah, I'll do 2 more questions, then we're going to topic 2. Go ahead. I didn't anticipate this much excitement. Go ahead.
So let's say that you're buying a property for an investor, and
Yes.
the other agent already knows that it's an investment,
Yes.
and you do leave that appraisal contingency on. But it appraises the value as is, but it doesn't give the value after repair. Can you still cancel?
I don't even understand the question. But here's what I can tell you. Let me make your question a little bit better. So if you have a deal for an investor, let's say it's an all-cash deal, and there's no appraisal contingency.
No,
If there's no appraisal contingency, and your buyer elects to get an appraisal and then cancels for some other reason, there's never an obligation to give the appraisal report when there's no appraisal contingency. Only when it fails to appraise for the value of the property in your purchase contract. Okay?
Okay.
So whatever your purchase contract is.
My question is on the other side, the buyer is an investor, and they left the contingency for appraisal. So that appraisal, because the appraisal they're getting has 2, the real value and the after repair value. So if the real value, okay.
Whatever contract price is, whatever your contract price is, that's what the appraisal based on. Whichever one your client agreed to pay the seller. Okay?
Okay, my question is, the seller already finished like a termite clearance, they done,
Yes.
but after the fire, they hired a different, termite company, and they got a report different for the seller.
Yeah,
one.
both reports. You give both reports to the buyer.
No, my question is, the seller has to do, for the buyer, the termite report.
I think so.
Well, I don't, what's the question?
Okay, seller, the termite report, they already finished.
Okay,
And the buyer, they don't trust seller the one, so they hired their own termite company, and the report come up is different.
depends on what the contract, you can allocate termite costs and repairs in your purchase contract. Whoever's allocated to that cost pays for that repair. If the seller says I'll pay for it, then it's their report. If the buyer's paying for it, then it's on their report.
I think I know what she's asking. I think she's asking if that second termite report says there's way more termite than this termite
Yeah.
report, and they already had, is the seller
The
obligated?
seller's obligated to do their report. If they agree to make the repairs, they get to choose the inspection and they get to choose the report.
And
Whoever wants to, if they want to have their own done, they can do additional repairs. But as long as the termite repairs and inspection are done per their contract, for example, if your seller signs a contract, says, I'm gonna do the termite, and I'm gonna get you section 1 clearance. And he gets termite from Scuffleupag's termite company, comes out and says, I can do it for $1,000, and they do it. And then buyer over here is disconsolate and says, well, it's gonna cost $100,000 according to my guy. If the seller does the repairs for $1,000 and gets a clearance for the buyer's obligated to accept it. Okay, because that's, yes.
Question on that, but then if after you, get the property, you do the inspection, and if it's not a clear inspection, if that fraudulent termite company did wrong, then you can always take them to the pest control
Well,
board.
I mean, we're getting kind of off track, going way down the rabbit hole. But here's the deal. First of all, we're assuming if the termite company's fraudulent. I don't know if that's an assumption we can make. If the termite company makes a mistake and they issue a certification, the certification generally has a guarantee for a period of time.
Right.
And then you can claim a warranty after close.
Right,
That
that's
relates
what
to
I'm-
the infestation that you find. And most licensed termite companies that are reputable, the ones you hopefully deal with, will come out and do it in supplemental eradication. They'll do it. Yeah, and there's lots of termites too, especially at the beach, by the way. That's the worst place in the world. They love it down there. But yeah, they're terrible down there. Every year you have to have your police exterminate. All right, so let's talk about commissions. Who likes commissions? Yeah, everybody. Well, some hands did not go up. Who likes commissions? And I can't believe there's some group over here that doesn't like it, but that's all right. I like commission. I like to be paid, and you guys like to be paid. But unfortunately, whether you represent a buyer or a seller, sometimes your buyer or your seller doesn't behave and ends up either going to somebody else and doing the deal you believe you put together, or violates your listing agreement and goes with somebody else and they do a deal and you get cheated out of your commission. And probably twice a week, I get a complaint by a selling or a listing agent that says, I'm mad, my client screwed me over, I want to sue. I want to sue my client for commissions. Now, what can I do? And it's usually just me and the agent talking at that point. So I'm going to just kind of educate you on the commission collection process, just so you have a little more insight of what it's about. First and foremost, the agent doesn't have a right to sue for commission in the state of California. It's a broker claim. The broker owns the commission claim. So any claim should come, the broker needs to be involved in any commission claim. Number two, there's a general rule of thumb. 99% of the time, when I get a listing agent or a selling agent complaining about commissions, 99% of the time, it results in me suggesting that they walk away and go on to the next deal. Why do I make that recommendation? Number one, it takes money and time to sue your client for commission. Number two, once you do sue your client for commission, every time your client goes to pick up their kid at soccer, guess what they're gonna say about you? And number three, guess what's gonna happen if you actually get a judgment for commission? They're gonna just not pay you or bankrupt out of it anyways. And then you end up out of pocket, at a time, a whole bunch of negative reviews online, and every time some kids play soccer, your name comes up. All right, so, and this is the reality of today's world. This is what happens. So 99% of the time, even if you have an ironclad commission claim and unless the broker really wants to pursue it, or it's an incredibly large commission.
I was gonna say, like, if it's a $200,000 commission,
Yeah.
then.
Well, I mean,
Let's
we've
go for it.
litigated a $200,000 commission.
Oh, we lost there too, though.
The guy who lives out of the country, so that was kind of tough. So, I mean, this is what happens on commission claims. They just don't pan out for the broker. They waste time, then you're gonna get bad mouth for the next 5 years, and they just make no sense. But if you do wanna pursue it, I'm gonna tell you just kind of, what the ground rules are. There's only really 2 ways that you pursue a commission. It's either your client breaches the listing contract, so you have a seller, the seller signs your listing contract, and then, uses, Acme Realty across the street to list and sell their house during your listing term, and you get cheated out of your commission. Well, I mean, you can sue for breach of listing contract if, in fact, the seller breached the terms of the deal. There is an attorney fee clause in the listing contract, so if you did sue your seller, if that was something you guys collectively as a broker and agent decided was a good move, you at least have an outside chance of the court awarding attorney's fees. But everything starts with mediation. So, you have to start with a mediation with your client, try to work it out, and if that didn't work, then you go to court and spend, $30,000, $40,000, $50,000 in court suing your client for commissions in either LA or San Bernardino Superior Court. You'd be, as an agent, footing the bill for that claim because that will be essentially your claim. There's not really much company dollar in it. So you'd be then, if the agent, the broker would decide whether to assign the claim to you, and then the entire claim would be personally your economic responsibility. That's how the commission claims work under the listing contract. That's the best case scenario for you. If you represent a buyer, we're working with what form now? The BRBC. And CAR has written that BRBC to be very friendly to the buyers. And so there's a specific attorney fee provision in the form that says the broker does not get attorney's fees by litigating a BRBC claim. So if your buyer screws you over and doesn't pay commission and violates every single term of the BRBC, your best day is to sue in either small claims court or superior court, get a commission claim, and you're out 100% of the attorney's fees. So if you have a $20,000 claim and you go to court and you spend $35,000 to collect the $20,000 claim, then that privilege has now, you're lost $15,000 even if the client pays the full settlement. So you can see why it doesn't make sense to litigate most of the commission claims for residential deals. Commercial deals, whole nother ball of wax. If you're selling a $25 million house in Newport Beach, or you're selling a $25 million building in Irvine, then the commission becomes a bigger number to play with. But for most of us in the residential world, the commission claims are relatively small compared to the cost of litigation. So let me just repeat it. Again, my recommendation generally is 99% of the time, you don't go forward with commission claim. If you do go forward with a commission claim, expect to spend a whole lot of your own money litigating it, and expect to get bad mouth for the next 5 years by your client and everybody at the soccer field and everybody at PTA. All right, any questions?
If I'm working with a seller who had a contract with another agent, but they're not happy with them and they want to cancel, but the agent refuses to cancel, then
Yeah, this happens a lot, by the way. I'm glad you mentioned it. It's actually a great question. So this happens, I get this call probably 5 times a week, by the way. Either
Wow.
email or call, literally 5 times a week. The agent's not happy with it, the buyer or the seller, they're not happy with their client, and they want to go with me. What can I do? And usually, if it's a listing side, the listing agent is asking me for advice on how you can help them breach that listing contract and get out of it. Which is, that's an interference with contracts. You can't really advise your potential seller how to cancel an agreement with another agent. It's a violation of the law to do that. But as far as how to cancel it, the listing agreement is an agreement for term. So it has a term in it. The RLA has for 2 months, 3 months, 4 months, up to 24 months. It could be a valid listing contract. You know the form. Does it have an automatic exit clause where you can cancel as a seller at any time? It does not. There's really no basis for it. If you get disconsolate or unhappy as a seller with your listing agent, it's really between the listing agent and the seller to negotiate a cancellation of listing. And you really, as a prospective future agent, can't be involved with the process. So here's how the discussion would go. I'm a prospective listing agent. That's a seller who's unhappy with her listing agent for another broker. So the prospective seller comes to me and says, I'm not happy with her. I want you to do the job. What can I do? As a prospective listing agent from Champions, I would say, you need to talk to your broker and negotiate a cancellation of listing. Whatever that means, you got to do it. I can't counsel you on how to do that. That's how you do it on the listing side. Buyer side's a little bit easier, because if there's a buyer that's been looking at properties, then at that point in time, you're talking about the BRBC. And the BRBC has a twin cancellation clause. You're aware of that. It's either exclusive or what? Non-exclusive. There's only two types it can be. If it's non-exclusive, then your buyer can cancel with that agent immediately upon written notice. So if she's a buyer and that's her BRBC agent and she's unhappy with her, she sends an email. BRBC canceled effective immediately. Love, buyer. It's canceled immediately. It's canceled immediately. And then if you're the selling agent who just received the cancellation, are you going to do anything? If you receive from your buyer a cancellation, you going to do anything? Yeah, you're going to do one thing. You're going to look up all the properties that you looked at, and you're going to say, these are the broker involved properties are these following addresses. You need to notify your next broker that I have a right to commission if you see these with anybody else. So that's what you do immediately upon receiving a notice of cancellation. Whether it's exclusive or not exclusive, you need to notify your buyer of broker involved properties. The ones that you showed them, the ones they saw during your BRBC, that way you preserve some right to commission. Okay, and you gotta tell them two things here. These are my broker involved properties. Here's the addresses. You need to notify your next broker that I have a right to commission on. That way you've set them up as a buyer that, fine, you cancel me, but I have a right to be paid if you don't tell your next broker about these properties. And you've set up a clear case for breach of the BRBC. So that's if it's non-exclusive. If it's exclusive, which everybody likes, it's cancelable only on 30 days written notice. That locks the buyer in for a longer period of time. So in that case, if your buyer comes in and says, I'm the new prospective selling agent, that's the buyer, and that's the BRBC agent. She says, I'm unhappy with him, but I've got an exclusive. What I can say as a Champions agent is, look, the only thing you can do is give her 30 days notice of cancellation, and then upon expiration of 30 days, you can come back to me. And that's your answer. That's all you can do. So that's the responses if you're a prospective future listing agent or prospective future selling agent, and you have a buyer or seller who's mad about their current agent. Now, the bigger question is, why are they mad? So that means you're going to be the next one they're mad at. I mean, typically speaking, when I interrogate buyers and sellers, when they tell me they're mad at their agent and they want to cancel them, most of the time it's not based on anything legal. They're just unhappy about something. Maybe they didn't return a phone call. Maybe they didn't get a call on their birthday. Who knows what it is? But it usually has nothing to do with the agent's performance. So just you might want to ask and say, yeah, why are you unhappy with them? What did they do or what did they didn't do? What do you think they should have done? That way you know why they're complaining about them, because you may be the next one that they're complaining about otherwise. And if they're just a problem, you might not want to pursue them. That's the last thing you guys need is a problem. All right? Any questions about commissions?
Is the agent as the exclusive selling agent, if they buy cancel the BRBC contract, does she still need to send her the confirmation of the listing of the house that she showed?
Okay, so anytime that your buyer cancels a BRBC, whether it's exclusive or non-exclusive, as a canceled selling agent on a BRBC, you need to immediately send a notice of broker involved properties to your buyer. It doesn't matter whether you're exclusive or non-exclusive, that fires out immediately. It's the same thing. This is a notice of broker involved properties. Here's the addresses you saw under my BRBC. You have a duty to tell your new agent about these properties, as you owe me commission on them if you see it with another agent. And if you do that, you put them on notice that when they go see her, they can say, oh, by the way, this is from my previous agent. Hopefully they say that. And then you know that if you do a deal or show her these properties, you owe her money. Okay, that's it. Anything on those issues? Yes.
I have a question about, like right now, like last investor, they buy the property,
Say it again?
For the investor by the house.
Okay,
And we show the property is person. But after they close, it's company the name. So how we can protect us to get a commission?
okay, so, I mean,
Like I show the property is by person,
okay,
and they sign the BRBC with the person's name. But after they change a different broker, and they close the property, it's company.
you know,
name.
that's like an enormous problem that I see a lot in residential deals. Most of the time, most of the buyers don't form corporations to cheat agents out of the commission generally. I don't know who's doing that, but if somebody does that, I mean, technically, I mean, if it's one and the same, then we go back to the breach of commission, breach of BRBC, or breach of the listing contract. I mean, if it's clearly a fraud,
Oh, yeah.
okay? Yeah, but if it's clearly a fraud.
Just curious.
Hopefully, it doesn't happen a lot to you. 'Cause I don't hear about it a lot. Okay, yeah. Yes, sir.
What about if the buyer didn't tell the selling agent about any signing before, and the sign was the buyer as a first
Yeah,
time?
I'm glad you mentioned that. It's a great question, and this is the problem we have, is that you have a BRBC and your client cancels you out and you send the notice of broker involved properties, but then your buyer never tells the new agent about you. And then you find out that they did a deal on a property you were involved with that was on your broker involved property list. Deals closed, agent number 2 got paid, you got a goose egg, and your buyer got the property that you showed them. So now what do? We're back to the commission claim. Now you want to sue them under the BRBC and spend the next year in court. You want to get bad mouthed at the soccer field, and you want to get bad mouthed at PTA. Those are the questions. So we're back to that. I mean, it's not a pretty scene for you guys, but the best thing to do, I mean, honestly, is if you guys really culture your buyers and sellers, hopefully you don't lose them like that. I mean, I know it happens, but I mean, your job is as a salesperson is to make sure that doesn't happen to the extent that you can. Buy them food, do whatever you have to do to make them happy. But then once they're happy, hopefully they don't go to another broker. Yeah, I mean, there's a bunch of cookies over there. Take some of those and probably give them to your clients tomorrow. And then they'll never leave. No, in all candor, this is part of our business. And salesmanship that's your department. And if you lose a buyer or seller, you need to figure out why and then deal with the issue. And that's not something legal. That's your department. You're the salesman. I'm not a salesman. I'm a lawyer. So that'll be something you guys have to introspectively say, okay, I lost this buyer. They went to this person. Why did they not use me? Why did they go to that person? What can I do to make it better? This is more of a motivational speech, but it has nothing to do with black letter law. Okay, that's all I have to say about that. Any questions about what we spoke about? Frankly, these 2 topics took 6 times longer than I thought it would, so I'm really impressed with the amount of questions you folks had on these 2 topics. But we're going to move on, and there was a topic that came up today that I'm going to just talk about a little bit, because I had one agent that sent me 27 emails this morning, not from this office, from LA office.
Oh, no cookies.
And this agent had no clue
No calories, no calories.
when a binding contract was formed based upon counteroffers, buyer counteroffer, seller counteroffer, and seller multiple counteroffer. They had no idea. I tried to tell them, and they seemed totally just befuddled as to whether they had a contract or not. And it's really pretty simple. So I thought we'd just kind of go over some just basics at first. I mean, if there's a buyer counteroffer and a seller counteroffer and a seller multiple counteroffer, those all have an expiration date. Okay? So when you dispatch it, doesn't matter which one it is, when do they expire?
3 days.
3 days from when? From the date that they're signed and delivered to the other side. Okay, so it doesn't matter if it's a buyer counteroffer, seller counteroffer, seller multiple, as soon as it's signed and delivered, that's when the counting starts. And what day is that? It's day 0. So if you have a seller multiple counteroffer and you represent a seller and the seller signs it today and you send it at 10 o'clock in the morning, today is day 0 and it's good for 3 days, right? So that would be, what would be day 2? What would day 1? Day 1 is Friday. Day 2 is what? Saturday. Day 3 is what? Sunday. So when would that technically expire? We think Monday morning, but because the expiration falls on a Saturday, Sunday, or holiday, it actually kicks over to the next business day at 5 o'clock, at 5 o'clock the next business day. So that means if it falls on a Saturday, Sunday, or holiday, the expiration, technically it doesn't expire until Monday at 5. Monday at 5. So be very careful on the calculations, because if you have an expiration that falls on a Saturday, Sunday, or legal holiday, just remember, that's not a cancellation date. I gotta go to the next business day at 5 o'clock before it cancels. Okay, 5 o'clock because the agreement specifies 5 o'clock. Other contracts, like the demand to close escrow and those things will expire at 11:59. A little bit different, but this is 5 o'clock. So let's say that you have a offer, and let's say it's a seller multiple counter offer, and you send it out today, and the buyer sends it back signed on Sunday. It's a seller multiple counter offer. You have a binding contract, because your seller now locked in on a seller multiple where they signed it today, delivered it today, and the buyer signed it on Sunday, and sent it to you. Is that a binding contract, or is it not a binding contract? Yeah, paragraph 8's big on the seller multiple. So it's not binding on your seller until they re-sign it on paragraph 8 and send it back to the buyer. So there's two things that happen. When you're talking counter offers, buyer counter offer, seller counter offer, and seller multiple counter offer, there's always a two-step process: signature and delivery. And those both have to happen for you to have an acceptance. So if your buyer, let's say, signed it on Sunday, but let's say the expiration is today. So today, let's say it's expiration at 5. This is when the seller counter offer expires today, and you represent the buyer. So your buyer signs it right now. So 11:40 or whatever time it is, 11 o'clock. Whatever time it is right now, your buyer signs it. But you send the seller counter offer at 5:01 this afternoon. Is it a contract or is it not? 1 minute late, it's out. Yeah, so 5 o'clock's your deadline. So if you're at 5:01, and that's what it says on your email when you send it, your client's out of luck. Now that's a counter offer. And it's not a deal unless the seller now signs it back within days. So it becomes a counter offer with the seller. So 5:01, it's no deal. 4:59 today, it's a deal. So be very, very cautious on your timing. 5 o'clock is a magic time. It's the pumpkin. 5 o'clock is a pumpkin. It turns in the contract and offer turns into a pumpkin at 5 o'clock, and it can't be accepted. Okay? Go.
I have a confession, I think, I don't know what it is.
Yes.
I always send a seller multiple counter offer, just in case I get another offer that comes in.
Yeah.
To get my, is that okay or not okay?
That's a great idea, except it's a form of fraud. But otherwise, so no, you're doing a good deal. It works.
Just confess.
It works perfectly unless an agent calls you on it and files a complaint with the board. If the agent files a complaint with the board, it's technically a CRMLS violation. Because you're saying, when you use the seller multiple counter offer form, what are you saying to the buyer? I have multiple offers. And if you don't have multiple offers, then it's a misrepresentation and it's a technical CRMLS violation. Okay? I mean, it's good for your seller, by the way. No, it's good for your seller, but it's a violation of the law. I'm sorry about that. So the question is, we're going to talk about, the question is, what is the CRMLS violation? What do you pay for that, right? So CRMLS publishes every year a list of fines that they assess. And the top fine that they can assess, and the one they seem to like the most, is $2,500. So it could be up to a $2,500 fine. So the worst that happens is you pay the fine and you move on for the first violation. If you do it every time and now you have 10 of them, it's probably going to lead to some formal arbitration or discipline, because it's obviously.
Thank you.
Okay.
You brought it up, I didn't.
Okay, I get sometimes some of my clients, when I present it with the multiple, I'm representing the buyer, and they say, well, they could just be doing that because they want.
Yeah.
And they'll just go and use it. And I tell them, no, it's in violation, and they wouldn't do that. How many agents really do that?
Lots of them.
I had no idea.
Everyone.
Lots of them.
I don't know what he
Yes.
is doing.
And by the way, I mean, it's a great strategy.
I don't know what he's
So I'm telling you as a lawyer, the potential downside. But as representing your seller, it probably helps them out, and certainly your seller would have no complaint. So if it's between a breach of fiduciary duty or a technical CRMS violation, you'll have to work as an office on what you guys want to do. I'm gonna get her, and then I'm gonna get you again.
So yes, I suspect that many agents do this, but how do we know? I mean, how would they get in trouble with that?
The only way they get in trouble is if there's if there's a complaint filed at the board then seeks a copy of all your files, and you don't have another offer on the file. That's when it happens.
So how do we protect the buyer against something like that? How do we protect them?
You know, all you need to do, I mean, there's really no way to do it other than threaten to file a complaint, then you're not gonna get the house. So this is just a game that we play. It's, you know, I know it's hard for some of you to believe, but sometimes agents aren't truthful in this business. And it's tough. You've never seen this before. This is probably the first time you've heard of this. But you just have to build that into your business. You just have to be suspicious about it. And then maybe write the listing agent, say, so you have multiple counters? You know, how many do you have? Where'd they come from? You know, you're gonna do a best and final. What are you doing? See, if you do a best and final, then you can have a right to review the other offers, and then they'll have to produce them.
Oh, you can? When
Yeah,
you say
you can-
best and final?
You can say that. You can say best and final, subject to review of the next highest offer, and then they'll have to produce it. If they can't produce it, then you know that the seller multiple counter was a fraud, was a fiction. Yeah, because that, like in his example, if you have best and final subject to review, and the seller wanted to accept it, now he's got to produce another offer.
So
Better find a buyer. It better predate this offer.
But as a buyer's agent, we can ask to see the other offers?
If you put it in your counter, you certainly can. That can be part of your document. You can write that in. You can always write it in. Whatever you write in your contract, that's the best defense you have. It's just write in and say, okay, here's my counter offer. You know, we'll pay this amount, subject to review of the next highest offer. You can do that. I mean, the buyer might not, seller might not accept it. I don't know. But that's a way to police it. At least you're telling them, I know your game. Okay, that's what I would do. Somebody over here have a question? Okay, right here.
Do we, as the listing agent or the seller, do we have an opportunity to provide if they ask to see?
Only if it's by contract, generally speaking. Only if it's by contract. So if you have a counter offer, which your client signs, that says you can give that offer up, then yes, you have an obligation to do it. But just because I'm a selling agent and I say I want to see all your offers, you have no duty to give it. Average off the shelf selling agent a copy of all of your offers. You have no duty. Those are confidential.
Even if we have an escalated clause.
It depends on how it's drafted. I mean, if you draft a counter offer that says that we have a duty to review the next highest offer, then they have a duty to provide it. But it's all driven on your contract language and in your offer, counter offer, multiple counter offer, whatever documents you're dealing with. If you put that in your counter offer language, and you have a right to review the next highest offer, then you'll have a right to do it if they sign it.
And if the seller don't want to entertain that, we don't have to answer.
If the seller won't sign it, then that's not a term. I mean, if I want to buy your house for 500 and you don't sign it, then we just don't have a deal. Same thing. If the seller doesn't want to sign a contract or counter offer that says they're obligated to provide a copy of the next highest offer, no deal. Either they sign it with it or they don't, in which case you default to standard counter offer. But that's the only way you can really police it. Okay? Any other questions? Okay. Keep in mind on disclosures, I'm gonna make a couple final comments. Since inspection disclosure is still a huge issue on liability, since all the cases I get, 90% involve inspection disclosure, just always keep in mind, I get calls all the time. It says, well, how do I know when, I need to disclose something on my app? How do I know where to draw the line? Is it a quarter inch? Is it a half-inch break? Is it a scuff on the wall? Is it a hole in the wall? Is it, a big piece of furniture? I don't know what's behind here. Should I disclose the big TV? I can't see condition of the wall. My sort of closing argument is I call it kind of the Fehlman two-step process on disclosing it. And the first one is if you're inspecting a property and you're concerned about something enough to look up my name, the answer is automatically disclosing. If you're so concerned as a listing or selling agent during your inspection that you're thinking of calling a lawyer to ask if you should disclose it, I can guarantee you it's important enough to disclose it. If you as a buyer, just pretend whoever you represent, whether it's a buyer or seller, whether you're a listing or selling agent, pretend you're the buyer And just ask yourself during the inspection, what I want to know about this condition, what I want somebody telling me about what I'm concerned about, the answer is yes, put it down. Again, after 30 years of doing this, I've represented literally, I mean, I'd have to say thousands of agents that were sued for not disclosing enough. I still haven't represented one agent that disclosed too much. So when in doubt, disclose it out. Simple as that. Yes?
Okay, I have a question about the fire, the fire environmental zone. Okay, in a contract, when we write that and they say, no fire, will be provided, no fire environmental report will be provided. That was in the counter offer, I'm representing the fire. So, but if the NHD says it's in a high fire zone, then it is required for that. So is that California law or?
California law, yeah. So the fire hardening and defensible state disclosure is statutory. So you have to complete, you have to provide it. Now, you don't have to you can allocate the cost for inspections and compliance, but you have to at least provide the form with section 1 and section 2 filled out.
So even though the listing agent said that's not going to be part of the contract, will not be provided, that's exact words.
It's a statutory document, so they're required to provide it. I mean, under the law, it's to be provided. But if they don't want to provide it, then you're going to have to advise your buyer that, they're not going to get this form. It's important because, it's the only way you can tell whether or not the property violates fire code. And then you're going to counsel your client and have them sign a disclosure or hold harmless, that they understand that they need to conduct their own due diligence regarding fire hardening and defensible space prior to close, because the seller refusing to provide the form. They hold you harmless. So that's what happens when the seller's foolish enough not to provide it.
So it's the buyer's responsibility to do that. Somebody has
If the
to
seller
do
won't do it, then it's the buyer's obligation. Because the seller is saying, I'm not gonna do it. Okay, yes?
If you're, let's say you're representing the buyer.
Yes.
And they do, the seller does repairs, but you ask them for receipts, but they refuse, they
Right.
just won't respond to you then.
Notice that what you do there is a notice to seller to perform under paragraph 15 of your RPA. Paragraph 15. If you read paragraph 15 with all the other provisions of the RPA that I told you to read when you go to dinner tonight, that one will say that the seller has an automatic obligation to give your buyer copies of all receipts for all repairs made prior to close. Okay, so 15 is your magic paragraph. Yes?
So I had a couple of situations the last couple of months where listing agents write up an offer, you're not getting a counter, your counter is in a paragraph format by the listing agent. And at this point, I don't even know if my offer has even been presented, rejected, nothing. The listing agent keeps writing up a paragraph saying, hey, we would want to see this, you need to correct this on your offer. My response is, well, have you even presented my offer? And all they did was just do presentation of offer. How do I really know that that's even being done?
You don't know. I mean, this is so non-standard that, what I would do is I'd send it to the broker, I'd look up the broker of record,
Okay.
and I just tell the broker, I've submitted an offer on this date, all we want to know is did your client get it, and do they have a counter? I have no idea.
Because I never got a formal counter, I just got a paragraph.
Yeah, I don't know what's wrong with these people.
Okay.
I don't know what's wrong. Yeah, that's so non-standard. That'd be like you saying, what do you want for lunch? And I'd say, the floor is brown. It's totally non-responsive.
2-8.
Yeah. Anything else? Going once? Okay.
Question about the WBSA balcony inspection report. Does that need to be approved like for the repairs?
Okay.
Or not really?
If your client's using financing and it's a condominium and the repairs haven't been made and there's no provision to make the repairs, there's gonna be no financing. So that becomes a big deal. So the balcony repairs as of this year, January 1, 26, all the inspections have to be done. Pretty much all the repairs have to be done on the condo units. Now, as the private properties, the repair is a little more flexible, but there's some conditions. For example, if there's asbestos found during the repair, then the condos or the private homeowners that have 3 units or more will have 9 months to remediate the asbestos, and then an extra amount of time to complete the repairs. So it's a lot more than I can really answer at this lecture, but if there's specific questions, I'll be delighted to answer them. And also we have a newsletter that answers everything that was circulated last year. That tells you everything you ever want to know about balcony laws. And it was print published and it's like 3 pages. And you guys have it. If you don't, call me on it. Yes?
And an avid, when you're doing an avid.
Yeah, my favorite document. I have made more money in my career off bad habits than any other document. It's my favorite document on the planet.
Okay, I do it an avid and I don't see nothing in one room or something. It's so beautiful, there's nothing wrong. What is the best thing to put? Nothing noted or nothing to know?
It doesn't matter. Nothing means the same thing, as long as you put something down there. Nothing noted is a perfectly valid response. But remember, there's always usually something to put down. If you walk in the bedroom and it's beautiful, and the bed's down there, you don't know what the condition of the floor is under the bed. So I mean, you could say, the condition of floor unknown under bed, because the bed's over top of the carpet. Or if there's a big piece of furniture, a big TV, you can make a disclosure. Condition of east-facing wall unknown due to television. There's always usually something that you can put. Remember, it's not just disclosing what you see that's bad, it's what you can't see. So if you can inspect portions of the property due to large pieces of furniture or large pictures, armoires, or what have you, you have a duty to disclose what you can't see also. So remember that in your avid. It's not just, I'm looking for defects. It's like, what can I not see? Then tell the avid. Unable to, condition of floor unknown because of large doorway. Condition of wall unknown because of large furniture on each wall. Condition of wall unknown because of football site. What is this? 8-foot line TV, whatever the case might be. So that's a duty you have as well. So what can I see and what can I not see? All belong in the avid. Yes.
On the avid, is it just what you can see? What if it's something like I open the window, it's not working? Is that something?
Well, that you're seeing it not working, so yes.
Okay.
Well, I mean, we can make it a question even better. What do I see? What do I hear? What do I smell that's a defect? So if you walk in and the house smells old, stuffy, moldy, whatever, you can note unusual smell by to investigate. If you walk in and you're in the house and it starts vibrating and you hear a train 1 block away and it's blaring so you can't even talk to the listing agent, you hear that? Agent notes large train whistle while in house during inspection.
But the question is, we don't have to inspect like windows or like, it's just.
You don't have to open and close things other than like under the sink. The most recent authorities recommend that the agents at least open up the sink just to see if, there's moldy water, whatever it might be.
Okay.
So that's what they kind of suggest, but yeah, opening up every closet, every window, that's an inspector's job. That's really not your job. You're not to do destructive testing. You don't need to go to the roof. You don't need to go in the attic. You don't need to go in the basement. This is a visual inspection. What do I hear? What do I smell? What do I see? That could potentially be a defect or a red flag. Remember, there's 2 things you're disclosing, defects and red flags. A defect is something that's wrong while you're there. The faucet leaks. I'm looking at it. It's dripping right there. A red flag is there's a stain in the middle of the ceiling. I don't know if the leak is still active. I don't know if it was from 20 years ago and the roof's brand new, but it's certainly a red flag that the buyer should investigate why that stain exists. So red flags and defects, 2 different things. You disclose both in your avid. What can I see? What areas can I not inspect? Because of carpets, furnishings. A lot of times it's garages. People turn their garages into like an exercise gym. And you can't inspect the floors at all. Once they take all that away, the garage floor is all chopped up. It's got cracks all over it. It's got it's high and lows, and it really should have been disclosed, but you couldn't inspect it because of the gym on it. So keep in mind, what can I not see? Put it in your avid as well. All right. Any other questions? Going once? Going twice? I'll be back probably before the end of the year. So if you forgot some questions, don't worry about it. I'll be back. If you have any questions about the RELS program, shoot me an email. It's still in effect. We're still working it out. We're still keeping everybody out of hot water on a daily basis. And any questions you have, you know where I live. Thanks, guys. Have a good day.
Everybody make sure you get a t-shirt.